Good afternoon, everyone. Thank you so much for joining us today for our free webinar, How to Adapt Your Medical Practice to the Evolving Workplace During COVID-19. My name is Allison Elsner, and I'm the Executive Director of the San Bernardino County Medical Society, and we're very excited to be co-presenting this webinar today with our partner, Component Medical Society, the Riverside County Medical Association. As many of you know, this has been a really challenging time. With COVID, we've seen closures of numerous medical practices, issues with working remotely, and so many risk and liability concerns. And fortunately today we have the expert here to join us to talk about how best to address all of these for those of you in the healthcare field and physician practices. I would love to go ahead and introduce our presenter today. Pamela Tahim Thakur is the founder and managing attorney at the Thakur Law Firm, APC, with offices in Southern and Northern California. She provides representation to individual and business clients throughout Orange, Riverside, Los Angeles, San Bernardino, Alameda, and Contra Costa counties in a variety of matters. Focusing her practice largely on litigation and transactional services, she has extensive experience in cases involving real estate, employment law, business disputes, tax planning, probate and estate planning and administration, and of course, healthcare law. Majoring in political science and Spanish, Ms. Thakur attended the University of California, Los Angeles, where she obtained a Bachelor of Arts in 2001. She then enrolled at the University of San Diego School of Law, where she participated in many competitions as part of the school's national trial team and was elected to the Order of Barristers. Ms. Thakur was awarded her Juris Doctor in 2005, and she's also the recipient of a Master of Law in Taxation from that school. Ms. Thakur has been selected by her peers as a rising star consecutively since 2017. Thakur Law Firm, APC, has been selected as the preferred law firm for the members of Riverside County Medical Association and San Bernardino County Medical Society as a business partner. She regularly provides lectures and presentations to the physician members of both of our medical societies on legal compliance and best practices. So before we jump in and turn this over to Pamela, I would just like to remind everyone that we will have time for question and answer following the presentation. If you could submit your questions, please, via the chat feature on your dashboard at the bottom of your screen, or your Zoom screen. We will go ahead and get to as many questions as possible. And following this presentation, the slide presentation will be shared with all participants. So at this time, we are going to go ahead and turn this over to you, Pamela. Thank you so much for being with us today.
Thank you so much for that wonderful introduction. I think we can actually go on to the next slide, Janice. And this does provide some background information about my firm, my involvement with the medical associations representing physicians since 2005 in a number of different areas, and so forth. So if you can move on to the next slide. So this is a disclaimer that nothing in this presentation creates an attorney-client relationship, and because the laws are changing so quickly, the information in this presentation may be obsolete within a certain time period. And just by way of example, as the laws have been changing, I did a presentation for both San Bernardino Medical Society members and Riverside County Medical Association members back in March on the Families First Coronavirus Response Act. There were, I think, over 300 members watching and trying to understand all the new regulations as they applied to employers and employees with respect to leave and paid leave. And just a couple of weeks after that presentation, there was an exemption for healthcare providers. So a lot of the information that was provided in that presentation changed, but there are nuances that we will be discussing today. There is a lot of information in this presentation. So if you can move on to the next slide, we'll we'll discuss what the topics are. I'm going to try to jam pack everything in 45 minutes. I know that there are a number of questions for the past 6 months. I have been getting all kinds of employment law questions related to handling employees during the pandemic. So what we've done is compiled some of the key questions that we've had to research and provide responses to our clients with. And that's what we're going to focus on. So if you could just go back, let me just highlight some of these issues that we're going to talk about today. So we're going to talk about some of the common legal issues, remote work considerations, workers' compensation, accommodating disabilities and complying with leave laws, complying with California privacy laws, and then frequently asked questions. You can move on. All right, so the common legal issues that we're going to talk about, you can move the slide. Okay, so the first, and I think most prevalent, is how can a medical practice comply with its legal obligation to provide a safe and healthy workplace during this pandemic? Another issue that we'll discuss is how should a medical practice handle an employee if an employee was exposed to COVID-19 at work? How should a medical practice handle employees working remotely? Sick leave, reasonable accommodations, wage and hour issues when employees are working remotely, confidentiality issues of employees, and how to handle employees who refuse to return or who are afraid to return to the medical practice. So I think what's really helpful for our clients is in order to be legally compliant and to protect the employer from any type of liability, it's very critical to have a checklist in place. And this is a checklist that we've given to a number of our business clients, medical practice clients, so they can just make sure they're following the specific government websites, updated laws, regulations, orders, and just to make sure on a regular basis that this is being done. So what is recommended is to find the industry-specific guidance, and we'll discuss what guidance specifically applies to healthcare providers. Then the medical practice should perform a detailed risk assessment, create a worksite specific protection plan, and then use that plan to train employees. So if you have a plan and no one really understands it, then it's not really doing much for your medical practice. In addition, training employees on screening themselves, setting up CDC control measures, developing an action plan for when there are suspected or confirmed cases, implementing sick leave policies and practices that are flexible and supportive, and then posting the completed checklist. What I highly recommend is that these policies and procedures be documented, that you have either these policies and procedures in an employee handbook, or that you have a COVID-19 addendum to your employee handbook that your employees understand and that they sign off on. And that is really the best way to protect your practice against any potential exposure. Moving on. So there are a number of regulations. You have federal, there's state, there's county. So some of the websites are here. So this presentation will be provided so you can take a look at the regulations, go to these websites. There's Cal OSHA, there's the Labor Commissioner's Office, of course, as well, as it pertains to employment law issues. Next slide. And then federal agency websites, the Center for Disease Control and Prevention, the CDC website, Department of Labor, EEOC, and then OSHA. So with respect to healthcare facilities, the CDC has very specific guidelines that we will discuss today. So for medical practices, what is really significant is to have certain telehealth and nurse-directed triage protocols. And for those of you that have your medical practices already open, I'm sure you're following these, but the CDC has specific recommendations. The website is on this specific slide. So for scheduling appointments for routine medical care, it's important to instruct patients to call ahead, discuss the need to reschedule their appointment if they actually have symptoms of COVID-19. Advise patients that they must wear their own face coverings, face masks before entering any facilities. And if they do enter your medical practice, have face masks available for them. There are nurse-directed triage protocols to determine if an appointment is necessary, and that is also on the CDC website. So if a patient must actually come in, those patients should be triaged, and the medical staff must take preventative action. Next slide. So if anyone does enter the healthcare facility, the medical staff should take temperatures of anyone entering the facility, documenting absence of COVID-19 symptoms. And in addition, if anyone has been diagnosed, tested positive for COVID-19, to self-quarantine. There should be very limited points of entry to the facility. There should be screening stations outside of the facility to screen individuals before they enter, so they shouldn't actually be all sitting in the same waiting room area. And in addition, you want to make sure that you have signs, posters alerting any patients, any third parties who enter the workplace regarding your policies and hand hygiene practices. And then in addition, you want to make sure that you have supplies for respiratory hygiene, cough etiquette, including hand sanitizer, tissues, non-touch receptacles for disposal, and patient check-in to be outside, or if it's inside, staggering the number of individuals who can actually enter the medical practice. So you want to implement universal source control measures using face masks, and for anyone who enters the premises, employees, patients, visitors, at all times, educating your employees, having this in your COVID-19 addendum, encouraging physical distancing. So you want to make sure that's specified. So if you have critical employees that need to enter and work in the workplace, they understand that there has to be 6 feet of physical distancing between them and other employees. Trying to determine if there are any employees who can work remotely, and if they can work remotely, we'll discuss the remote telehealth policies that you can establish for those employees. And then, of course, implementing universal use of PPE for all of your employees. Now, in addition to that, your medical practice can provide targeted testing for your employees. And also, in addition to that, if you have elective procedures, you want to make sure that these patients understand that they can be postponed, so you don't have a number of patients coming in at the same time. And then in addition to that, using engineering controls, indoor air quality, and so forth. So move on. So what's really significant here is that you do want to have a detailed risk assessment plan. So you want to have someone that is designated as a COVID-19 response coordinator. I think that's very significant. You don't want to have a number of different people who are trying to interpret and manage the employees. What you can do is have a specific individual who's involved with managing, dealing specifically with patients, and then also have someone like an office manager who would be a COVID-19 response coordinator. This individual should essentially manage how control measures are being set by your medical practice and screenings, confirming that cleaning and disinfecting protocols are taking place regularly, making sure that the employees understand that they need to manage physical distancing in addition to that with patients, in order to maintain the availability of personal protective equipment, and also who is confirming that the employees are receiving adequate training and that there is compliance. And the best way to do that would be through documentation and having the employees signing off on the policies. Now, pursuant to the CDC, this was released on August 20th of 2020. There is guidance specific to how to have an action plan for suspected or confirmed asymptomatic versus symptomatic cases. So this is how in a medical practice should handle a situation if a healthcare provider has had prolonged close contact with a patient, a visitor, or another healthcare provider with confirmed COVID-19. So depending upon different factors, for example, whether or not the healthcare provider was wearing a face mask or eye protection, or was not wearing PPE or anything like that, there are work restrictions that are guidelines from the CDC of how to deal with those situations. So if there's also a healthcare provider with a mild to moderate symptoms or severe or critical symptoms, then there are certain guidelines that should be in your policies as to how many days should pass after an employee should then return to work. So this is criteria that is evolving. It's very critical that you are watching the CDC guidelines to make sure that your policies are also evolving with the guidelines. Again, this is another test-based strategy that the CDC recommends for the return to work criteria for a healthcare provider who has a COVID-19 infection, whether or not they can return to work, and essentially how many days apart testing should occur. And that's something that you would need to monitor with the CDC. So what's really significant, and we've seen a lot of issues that have arisen regarding a COVID-19 employee that may test positive, is maintaining confidentiality. How do you respond to other employees if there is an employee who actually tests positive? Well, the first thing that you need to do is you need to maintain confidentiality. That is very critical. You can let the other employees know that there has been an employee that has tested positive, but you cannot under any circumstances provide that individual's name to the other employees. If that employee is comfortable with you providing the name, then in that situation, I would certainly get something in writing as a waiver, just so that the other employees who have been in contact or potentially exposed, they do need to be notified, but the notification has to be provided without specifically naming the employee who has tested positive. And for those who have been in close contact with that individual, they should be given instructions to quarantine and also monitor any symptoms that they may have in addition to getting a COVID-19 test. And information should be provided to employees who are sent home about their sick leave rights. Now, under the Families First Coronavirus Response Act, healthcare providers are exempt. However, you should have sick leave policies that do that would be in play in the event that any of your employees do get sick. So it is important to have flexible sick leave policies despite the FFCRA not applying. And that is not, the application of that is as to whether or not you have to pay the employees. And in addition to that, employees who were never symptomatic and did not have close contact So if you have employees who did not have any close contact with a positive tested employee, then those employees may continue working. But for any employees that had close contact, it is very important that you do advise them without providing the specific name of the individual who has tested positive, so that they can get tested, so that they can check and see if they have these symptoms, and certainly quarantine as well. In addition, it is very important to perform a deep enhanced cleaning and disinfection if there has been an employee or a patient with COVID-19, especially the area where that individual was sitting, their workstation, if they were using any computers or phones or anything of that nature. And I would recommend using a professional cleaning company. There should be ongoing enhanced disinfection following CDC recommendations. In addition to that, you should not encourage employees who are potentially using, the same area of work to use any of the same equipment that should not be shared in any respect. So phones or computers for billing or anything of that nature, there should be separate, basically they should not share at all, just to be safe. In addition, there should be training of employees on using cleaners and disinfectants and necessary PPE. So in addition to that, it's important to investigate and analyze exposure incidents, and if necessary, also providing that analysis to the local health department and contacting OSHA. And you can move on to the next slide. Again, as I mentioned, it's important to have sick leave policies and practices that are consistent, and not to discriminate between employees. So that's why it is significant to have an employee handbook or COVID-19 addendum that outlines the sick leave policies that you have, particularly for healthcare providers. And if you're not offering any sick leave, so California has specified paid sick leave. You can do it through a PTO policy, and as long as the PTO, the number of hours for PTO, it exceeds the paid sick leave statutory minimum, then the employees should be able to take that time. Move on. All right, so remote work considerations. There are a lot of issues that actually have arisen as a result of remote working, and it is an effective control measure to control the spread of COVID-19. So what your practice should do is determine, number one, which employees you have that are eligible for remote work. So this could be case managers, this could be administrative employees, this can be financial billers, it can be IT individual workers, or any other employees, including physicians who are engaging in telehealth services and nurses. But the reason this is significant is because employees who are working remotely have the exact same protections as employees who are working in the workplace. So what this means is that the wage and hour regulations that govern employees, that still applies. So if you have an hourly employee, you still need to make sure that they're getting their 30-minute meal break. You need to make sure that they're still taking their 10-minute rest breaks, which should be in the middle of every 4 hours. And how do you implement that? Well, you need to have a remote work policy that outlines all of these regulations and that your employees sign off on. In addition, for employees that are working remotely, there should be expectations of productivity and communication and performance. And in addition to that, tracking and reporting of time needs to be specified in these policies as well. So another big issue that's come up is whether or not the medical practice needs to provide the equipment to the employees that are working remotely, or can they use their own laptops? Can they use their own computers? Can they use their own cell phones? Can they use their own, internet, and so forth? So the bottom line is that the employer has an obligation to actually either compensate the employee for whatever equipment is being used if they're using their own equipment, or the employer has an obligation to provide that equipment, those resources to the employees. So that is something that should also be outlined in any workplace, remote workplace policy for your employees. Under California Labor Code Section 2802, an employer must indemnify an employee for all necessary expenditures incurred by the employee in the direct consequence of his or her duties. So anything that the employee is using to work remotely should be compensated to that employee, or the employer should provide it. In addition, travel time also has to be compensated. Employees are entitled to overtime pay. So if they're working for more than 8 hours in a day or 40 hours in a week, they must comply with state and federal laws. Then these employees would be entitled to overtime. Now, the reason this is so significant to have a policy in place and to have time tracking is that if an employee is not getting paid overtime, if an employee is not taking his or her breaks while working remotely, this employee may file a wage and hour claim against the employer, and the employee would be entitled to prevailing party attorney's fees and costs, and that can be very costly for the employer. So there should be some ability to consistently monitor the employee's time on real time. And if the employee is not following what the employee handbook provides, that employee should be admonished. And it's important to document anything where the employee is actually not providing his or her time records, because the burden is on the employer to provide the time records. If there is a dispute whether or not an employee is actually getting his or her meal breaks, or whether or not that employee is getting paid overtime. So this is very significant because of the statutory penalties that are associated with not providing these to any hourly employees that are working remotely. In addition, if an employee is working remotely and they get injured while they're working at home, the question arises, is that something that would be covered by workers' compensation? Now, technically, that would be not, so it depends. There have been some cases recently that have been filed that have been very surprising, where an employee was working remotely and in the course of working for the employer during those hours was injured and filed for a workers' compensation claim, and that was actually covered. So we'll discuss that in the next couple of slides. We can move on. So what we're seeing in terms of the likely workplace litigation claims are the failure to reimburse for telework expenses, failure to reimburse for PPE, violation of the California Consumer Privacy Act. So where employers, if someone is actually has tested positive for COVID-19, instead of protecting that individual's privacy rights, inadvertently providing that employee's name to other employees, missed meal and rest break claims while employees are working remotely, unpaid overtime, misclassification, and age, race, disability, discrimination, harassment, or retaliation claims. In addition, there are a rising number of whistleblower claims for employers who are not complying with county, state, or federal guidelines, and then later on somehow are terminated for performance issues, and they claim that it was because they raised the issue either to the employer or to some other governmental agency that the employer was not complying with protecting the safety and workplace of the other employees. So under the California Fair Employment and Housing Act, it is unlawful to discriminate against individuals based upon their race, color, ancestry, national origin, religion, age, and so forth. And initially, when COVID-19 was first referred to as the Wuhan virus, there was a noticeable increase in discrimination against Asian Americans. And so it is very important not to refer within the workplace to the virus as being associated with a specific group of individuals. And as an employer, employers are obligated to avoid discriminating against older employees or disabled employees. So even if the employer's intentions are good, if the employer feels or says that something along the lines to an employee who is older or who has some pre-existing medical condition that the employee cannot work or should not work in the workplace, that could be seen as discriminatory if that employee cannot work regular hours, or the employer is making that comment in good faith, but if that employee shows that because of that employee's age or disability, the employee was being discriminated against. So if these issues do come up, I strongly recommend that you contact legal counsel to assist in navigating how to deal with those types of employee situations. Next slide. So on May 6, 2020, there was an executive order by Gavin Newsom. What that order did was it essentially tried to take the liability for any COVID-19 injuries or anything related to the infection itself from the employer's liability to be handled exclusively through workers' compensation. And what this order did, and it's about to be codified into law, is that it said that any COVID-19 related illness shall be presumed to arise out of and in the course of employment for purposes of awarding workers' compensation benefits if the following requirements are met. Number one, the employee tests positive or is diagnosed with COVID-19 within 14 days after a day that the employee performed labor or services at the employee's place of employment, excluding the employee's residence at the employer's direction. So if someone was working at least 14 days prior to having a COVID-19 positive test, it creates a presumption that the employer would be responsible and that the workers' compensation claim made by that particular employee would not be denied. The date of the employee performing that work, it had to be anytime after March 19, 2020. The workplace could not have been the home residence, and a diagnosis of the COVID-19 positive test has to be made by a physician and issued by the physician licensed in California, basically, and also confirmed by testing within 20 days of the date of the diagnosis. So moving on to the next slide. So one of the differences with regular workers' comp claims versus anyone who's making a claim for injuries due to COVID-19 is that the time period to deny the claim is shortened from 90 days to 30 days. And if the claim is not denied within the 30-day period, it's presumed compensable, and it can be only rebutted. So it's a rebuttable presumption if the employee can show through evidence, well, the employer can rebut it, basically showing that the employee contracted COVID-19 from some other source, from being elsewhere. It is a very, very difficult presumption for the employer to show. So most of these claims for employees who are filing for workers' compensation will generally be approved. Next slide. And as I mentioned, this is going to be codified into law. It has recently passed the Senate, so there were actually a few bills that were proposed. And the one that was actually passed was Senate Bill 1159. Basically, this creates a rebuttable presumption for critical employees. And so if you have an employee who tests positive for COVID-19, that employee can file a workers' compensation claim, and that would most likely be presumed to be from the workplace. And this rebuttable presumption is being extended to January 1st of 2024. So the next topic is disabilities. So FMLA. So COVID-19 qualifies as a bona fide disability. So that is protected under FEHA, and that triggers the employer's duty to engage in the interactive process and reasonably accommodate the employee's disability, unless it would create an undue burden for the employer. So the burden is on the employer. So if you have an employee who has COVID, who has any type of COVID-19 diagnosis or symptoms, and it creates a situation where that employee is unable to perform at full capacity, even though based on the CDC guidelines, that employee can return back to work, the employer has an obligation to try to reasonably accommodate that employee. So for example, if that employee was a nurse and regularly working with patients in a very active capacity, and due to contracting COVID-19, is unable to perform at that same capacity and cannot interact with patients, then the employer does need to see if there's any other position that the employee can fulfill, even on a temporary basis, to avoid being in violation of any FEHA or FMLA leave protected regulations. In addition, the employer must reinstate the employee, if the employer can, to the same position if the employee had to take time off from work, either to get tested or for treatment or anything of that nature. So the Families First Coronavirus Response Act, this was, when this act came out, everyone was up in arms trying to figure out what does this act mean? Does it apply to me? So for healthcare providers, this doesn't apply to you. However, the reason this is very significant, and the reason we bring this up in this presentation, is that even though you don't have to pay your employees if they had any of the issues pertaining to the Leave Act, that they're subject to quarantine or an isolation order, or they're advised by a healthcare provider to self-quarantine, or they are experiencing symptoms associated with COVID-19 and seeking a medical diagnosis, or they are caring for an individual subject to a quarantine or isolation order, or caring for a child who is in school, but their school is closed due to coronavirus related reasons, or if they're experiencing any of these conditions that are identified, then the employer doesn't have to pay these employees, so there's an exemption for that. However, if the individual must take leave because of any of these reasons, then the employer still has to allow that employee to be reinstated in their job. Okay, so just because the Families First Coronavirus Response Act doesn't apply for paying healthcare providers, any leave that would be taken is still protected. So this has come up quite a bit where medical practices are dealing with employees that have to care for their children, for example. And so the employee technically has to work remotely. And if the employer does not allow that employee to work remotely or make certain accommodations, then they have to show it's an undue burden. It's just not possible, because anyone who needs to take a similar leave such as this and under the Families First Coronavirus Act, even though they're not getting paid, they would certainly still need to be reinstated as employees. Now, something interesting with the Families First Coronavirus Act that came out. So the Department of Labor is continuously changing and expanding and clarifying definitions. So an interesting change that took place in the last couple of weeks is that if there is a school that is open not just for distance learning, but for some type of variation, and the employee doesn't want to send his or her child back to that school, then the leave provision does not apply. So there's no protection if the child care facility is even open for temporary in-person attendance or full-time attendance. So then the leave protection would not apply for those employees. Next slide. So healthcare providers are exempt. We've discussed that. Emergency responders are exempt from the paid provisions of this leave, FFCRA. Actually, can you go back to the last slide? So there is actually a more narrow definition for healthcare provider, and this is extraordinarily significant for anyone who's managing a medical practice, is that previously the definition was including anyone that was essentially working at a healthcare facility. Now, this does not include IT workers who work at your medical practice, and it does not include medical billers. So before, if you were categorizing these individuals as being potentially exempted because they were working in your healthcare facility, now they are not considered exempt as healthcare providers. However, there is an exemption, even if they're not considered healthcare providers. If your practice has less than 50 employees, you can also claim the exemption based on certain factors. So if you can go on to the next slide, and then the next one. So essentially, if you have less than 50 employees, you can claim an exemption from this leave, from the paid portion of the leave, if an authorized officer of the business has determined that providing such leave would result in the business's inability to continue operating at minimal capacity, or that it would significantly affect the business in a way that it would not be able to meet certain financial obligations. So let's move on to the next slide. What the last slide was saying is that I have some healthcare providers that do choose to not exempt the practice from providing paid leave benefits because it increases morale for their employees, and because of the tax benefit with the payroll tax being not having to pay the payroll tax upfront. It is a benefit for certain healthcare providers. So even if you are exempted, there could be other benefits to actually follow the paid requirements of the FFCRA. So the other new law that we need to be aware of is that employers, they must provide notice to employees that information will be collected during health screenings or temperature checks, and take reasonable security measures to safeguard that information. So this notice is required to be provided to your employees. If you don't have that, you should certainly contact us and we can assist you with that. It is a law so that the employees understand that the medical practice is complying with safeguarding their information. And there are penalties. So just going back to that really quickly, that slide, failure to provide this notice is a very, very significant issue. So if you're not providing this notice to your employees, there are civil penalties associated with this, $2,500 for non-intentional violations, $7,500 for an intentional violation. So it is important that you do comply with this, and we can help you with that. All right, so as I mentioned, over the last 6 months, we've been handling a number of different questions related to employees, specific to healthcare providers. And one of the questions that came up was whether or not testing for antibodies was sufficient for employees in the workplace. And the CDC does not recommend using antibody tests to determine which employees can work or to check for past COVID-19 infection. And that is because the information and research is not confirmed as to whether or not someone in the past who had a past COVID-19 infection could then become reinfected. The next question that we've seen is whether or not healthcare providers must provide masks, respirators to employees, and of course, healthcare providers must always wear face masks. In addition to that, healthcare providers must provide N95 or higher level respirators for certain procedures, including aerosol generating procedures and surgical procedures that might pose a higher risk of transmission if the patient has COVID-19. So it's not just the regular face masks that are required. Another question that we've encountered is, what if an employee appears ill but refuses to leave the workplace? Is that considered discrimination? And no, that's not discrimination. If you have an employee who is coming into the workplace and has certain symptoms that seem to be related to COVID-19 or otherwise, that is not considered discrimination to ask the employee to leave the workplace. But you do need to explain to the employee the public health nature of the request so that they cannot potentially say that it was because of their age or because they have a disability or something along those lines. You should also offer at that time to allow the employee to use paid sick leave or some other PTO policy that you have available. What if an employee refuses to return to work? Now, this one, I think I've had 3 or 4 medical practices contact me regarding this issue. And an employee can only refuse to come to work if they believe they are in imminent danger. So this danger must be an immediate threat, imminent and immediate, and quite frankly, most workplaces, including healthcare facilities, they just do not meet the elements required. And as long as you are following the guidelines, and I'm sure, you know, with most medical practices, if not all, are, and I'm sure everyone on this presentation is quite conscientious because you want to make sure you're following all the guidelines. So it would be very, very rare and very unlikely for an employee to show that the threat is imminent or immediate. So if an employee does refuse to return to work and it's not because they're in some sort of protected leave or anything of that nature, then that is considered job abandonment. The employees cannot just claim that they are afraid of COVID-19 and not come back to work. Okay, then what if my, this question has come up as well. What if my employees are refusing to work, refusing to return to work because the unemployment benefits are more than the regular wages? So any employee who's been made an offer of reemployment is no longer entitled to collect unemployment benefits. So that would be something that would essentially be a job abandonment issue as well. Another question that's come up is, if an employer is hiring, may it screen applicants for COVID-19? The answer is actually yes. So, but you have to make a conditional offer of employment. You cannot screen them prior to making a conditional offer of employment. You can provide a conditional offer that says that a condition of them actually becoming an employee is that they will test negative for COVID-19. That is not discrimination. That is a public safety issue. May an employer withdraw a job offer when it needs the applicant to start immediately, but the individual has COVID-19 or related symptoms? The answer is yes. That is not discrimination. Based on current CDC guidance, such individuals cannot safely enter the workplace. So yes, the employer may withdraw the job offer. May an employer delay an applicant's start date who has COVID-19 or related symptoms? Yes. According to the CDC, those individuals should not be in the workplace. May an employer take an applicant's temperature as part of a post-offer pre-employment medical examination? Yes. And then, do employers need to report COVID-19 illnesses to Cal or to OSHA? So only if the employee becomes ill at work and is admitted as a patient at a hospital other than for observation or testing. That question does come up quite a bit. And then whether or not an employer must record the illnesses on OSHA Form 300 logs. And so yes, in these circumstances where the illness results in death. Days away from work, restricted work, transfer to another job, medical treatment beyond first aid, loss of consciousness, significant injury, or other illness. And I think there may be, I know we just have a few minutes. So, okay, so one of the questions, yes, Allison, did you want to ask me those questions?
Sure, thanks, Pamela. We just have about 5 minutes left, so we've only had one question come in on the chat. And so, Daria, why don't you read that for us, and then Pamela can answer, and we can get wrapped up.
Sure, not a problem. The question is, What is considered an unreasonable burden for a small medical practice employer?
So this really is a gray area, and what you will have to show is that you are financially, due to certain financial conditions, this employee simply cannot be accommodated. So for example, you would need to try to create a reasonable type of, so if someone, for example, let's say there's a job restriction, someone cannot lift more than 15 pounds, for example, or shall not be in close contact with patients due to certain medical restrictions. Well, then in that situation, you will have to see if there's another position that could financially be feasible for your practice. And if that is not feasible financially, you do need to keep track and document the fact that you would not be able to create a position that's not necessary for your practice. So, if your practice requires patient interaction and you cannot put that individual into some sort of administrative position, you would need to document that. Unreasonable burden is a financial burden. So you would need to show, if you have a small practice, that you could not financially afford to create a new position for that employee, and that it would affect the medical practice's bottom line, essentially.
Okay, great. We do have one more question that just came in, and that is, if you do not disclose which staff has COVID, then how do you ask other staff members who have been in close contacts with that particular staff?
That is an excellent question, because we've had to do that with some of our clients. So they will know who that individual is, but you cannot provide the name of that individual. All you can let the other employees know is that there has been an employee that you worked closely with who has tested positive for COVID-19. We cannot disclose the name of that employee. However, per our employee guidelines, CDC guidelines, and so forth, we are recommending that you closely monitor your symptoms, or that you quarantine for a certain number of days, or that you get tested for COVID-19 to see whether or not you have a positive test. So, I mean, it will be obvious to those employees who that individual is, and however, you cannot disclose that individual's name under any circumstances, unless that individual voluntarily agrees to that, and you would definitely want to get that in writing if that's the case. And even then, I would recommend using caution.
Okay, I have one other question. Should folks check their county public health for HCW protocols?
Absolutely. So it's really important to check. So there's county, state, and federal guidelines. And then the question is, which one do you follow? And so generally, what I tell my clients is you want to follow the most restrictive guidelines to make sure that you are doing what is necessary to protect your employees.
Okay, and I have, let me double check. I have one more question that, oh no, let me see. I received, there's a message on here from Dale, and I do not have your question in my inbox. I apologize, it hasn't come through yet. So what we can go ahead and do is I can send you that question, Pamela, separately.
Sure.
Okay, wonderful. And that's all we have.
And, yeah. And then, I just noticed this last slide that my staff put on here. So certain things that we can help you with include preparing your employee handbook addendum if you already have an employee handbook, remote work policies, checklists, and so forth. So if anyone needs help with that, feel free to contact us and we would be more than happy to assist.
All right, fantastic. Well, Pamela, thank you. That was so informative, and obviously it's helped a lot of people today, and we are glad that we have the opportunity to reach out to you. Any of you can feel free to follow up with Pamela. I know her contact information was on the slide, and you also are welcome to find that on our website, sbcms.org. On behalf of our partner, RCMA, and all of us at SBCMS, we thank you so much, Pamela, and Takura Law Firm for your expertise and your time and serving as a very valued business partner with us. We do want to remind everyone to please be sure to register for our upcoming webinar on October 14th at 6 p.m. presented by NorCal, which is about cultural bias in healthcare. So that's going to be a very deep dive into that topic. Again, thank you everyone so much. Thank you, Pamela and Takura Law Firm, and we hope everyone has a wonderful afternoon. We appreciate all that everyone's doing at this time. Thank you.
Thank you.
Bye-bye.